other jurisdictions where we're seeing dramatic backlogs in the judicial system. So, for example, in Brazil, there are 80 million pending cases, even though judges decide an average of 11 cases per day. And in India, there are 50 million pending cases, including 180,000 cases that are more than 30 years old. And the challenge is not just about a lack of time or resources, but also the fact that the right to a fair trial is complicated. As our co-founders wrote in their book, the right to a fair trial is actually broken down into 13 different component rights, which have been interpreted by 25 international human rights bodies across more than 28,000 decisions. So for judges and defense lawyers that are struggling with time constraints already, they really don't have the time to go through all of these decisions or a 1,000-page textbook about how to protect the right to a fair trial in judicial proceedings. So at this point, we might ask, well, surely AI can change that. If judges are overwhelmed and lawyers are overstretched, if the law is too complex or too difficult to navigate quickly, isn't this exactly the kind of problem that AI was designed to solve? But here's what we found when we interviewed judges for our AI Justice Atlas. In many jurisdictions, AI tools are being developed for courts by commercial technology companies, often not in local languages, and judges are not being given mandatory training on AI. For example, a recent UNESCO survey of judicial actors around 96 countries found that 44% are already using AI tools in their work, but only 9% receive training on how to use them. So the technology is moving faster than the safeguards, and that's the problem that we're trying to resolve.
Yeah, thank you, Daisy. That's clearly sets the challenge. So let's move from why to what. What exactly is the fair trial advisor, and how was it designed to address the challenges you have just described?
Thank you. I'm just trying to change. There we go. The Fair Trial Advisor is an AI-powered expert system designed to help judges and lawyers navigate the complexity of the right to a fair trial. This is a right that 175 states parties have consented to under the International Covenant on Civil and Political Rights. As I mentioned, the right to a fair trial is a complex rule, and the body of law is so vast and difficult to access quickly in the midst of actual proceedings. The advisor is designed to solve that access and usability problem. It is trained on the 1,000-page book, The Right to a Fair Trial in International Law, and The Freedom of Speech in International Law, written by our co-founders, which systematically analyzes and synthesizes those thousands of decisions by component. So instead of requiring a judge or lawyer to search through databases, indexes, chapters, or more, the FTA allows them to ask the practical questions in plain language. For example, can a trial continue if a defendant becomes ill and leaves the courtroom? Or does the use of covert recordings violate the right against self-incrimination? What safeguards are required when AI-generated evidence enters the courtroom? The system then provides a clear, structured answer grounded in authoritative legal sources with citations and reasoning. In terms of the technical elements, the Fair Trial Advisor uses a retrieval-augmented generation system. This means that the AI does not generate answers from general training data. Instead, it retrieves relevant material from a pre-approved legal data set and generates responses that are grounded in those sources. This approach mitigates the hallucinations concerns that we're seeing across a number of jurisdictions and ensures traceability and accountability. As Wasim said, the tool is being developed in partnership with Microsoft's AI for Good Lab and the Office of Responsible for AI, who are serving as both technical and thought partners. And now just briefly mention that, importantly, the Fair Trial Advisor is not supposed to replace human judgment. It is a support tool only. Its purpose is to assist judges and lawyers by making binding international standards accessible instantly, reducing the time spent searching through materials, and helping ensure that proceedings meet due process standards.
Thank you, Daisy. Now that we understand what the Fair Trial Advisor is, let's make this more concrete to the audience. Could you walk us through the typical use case where a judge or lawyer might actually ask the Fair Trial Advisor, and what kind of response they would receive?
Yes, and I think we have a video demonstration, if it's going to, yes. So this is the Fair Trial Advisor as it currently stands. It looks a lot like a chatbot, but it's more. You can type in a question at the bottom. So the first question that's being asked is, the defendant has fallen ill and left the courtroom. I'm not sure when they will return. Can I proceed with the trial with their counsel present? The Fair Trial Advisor then provides a response with clear citations to legal decisions. Sometimes it asks you a follow-up question for clarification, and once you respond, it will give you a clear answer with citations and a conclusion. So as you can see, here are the citations, which are all accessible in the book, but they're also cited in full format with the references to the data. And then there are other examples. For example, you can ask it, I'm a judge in a criminal trial. The trial was scheduled to take 3 days, but I think I've heard enough after 1 day. And you can ask the tool whether or not it's legal to end the trial early. The tool will then give you a clear response with a recommendation at the end, which I hope it's doing on screen, but I might be premature. But there's the demo.
Interesting, really, really nice tool. So that brings us nicely to how this tool was tested in real-world scenarios. So Daisy, you mentioned a hackathon. You have mentioned a hackathon. Could you describe what the hackathon involved and what you were hoping to learn from it?
Yes. Sorry, we mentioned it in discussions before this, that's why. The hackathon was a day-and-a-half event held at the University of Oxford back in January. And it was aimed to bring together judges, magistrates, lawyers, technologists, academics, civil society representatives, and students. It was designed as an official pre-event for this summit and marked the first structured co-design phase for the Fair Trial Advisor. So at the beginning of the event, participants were introduced to the conceptual foundations for the Fair Trial Advisor, the structure of fair trial rights under international law, the technical architecture of the prototype, and UNESCO's ethical frameworks for AI and the rule of law. From there, the hackathon moved into a hands-on collaborative discussion. So participants were divided into groups and asked to engage directly with our prototype, and the discussions were structured around 3 core challenges. First, user experience, how the tool should function for different audiences. Second, ethical and transparency frameworks, so what safeguards and governance principles should guide its development. And third, legal knowledge curation and integration. So this question is about how to structure and prioritize the authoritative legal resources. And the aim of the hackathon was not to provide a finished product, but to stress test and early design choices and to ensure that the tool was being built with the people that were actually going to use it. So what we aimed to achieve was threefold. First, we wanted to clarify the tool's core purpose and target audience. Like I said, the right to a fair trial is complex and context-specific, and different users, including judges, lawyers, or frontline advisors, have different needs. So the hackathon helped us think clearly about where the tool could have the greatest impact. Second, to ensure that ethical safeguards and trust are embedded within the product from the outset. So given the sensitivity of judicial decision-making and the risks of over-reliance on AI in the justice sector, we wanted early, candid discussions about transparency, accountability, judicial autonomy, and misuse prevention. And then finally, we hope to refine the legal architecture of the system. So the Fair Trial Advisor is grounded in authoritative source material and uses, like I said, a RAG-based approach to minimize hallucinations. And the hackathon allowed us to explore how international standards, domestic law, and evolving jurisprudence should be curated and integrated in future iterations. So in short, the hackathon was our co-design exercise. It brought together expertise that no one single person could bring to the table alone, and it allowed us to move from abstract visions into practical design questions. Yes.
Great, Daisy, to hear about the hackathon. So let's move on the validation and the user feedback. So once people started interacting with the advisor in this scenario, the next questions I would ask is, what did they actually think about the tool?
I think I have, yes. So you might not be able to see it from the slide, but the result of the hackathon was overwhelmingly positive. The vast majority of participants said that the Fair Trial Advisor was useful to supporting fair justice systems and fair trial guarantees. On this slide, you see that the two most common strengths identified were first, that the Fair Trial Advisor saves significant time in legal research, and second, that it provides clear and well-structured guidance. We also received some qualitative feedback, which has been really useful in our post-hackathon discussions with Microsoft's AI for Good Lab. So first, a lot of the participants focused on the usability of the tool. They flagged practical issues, things like enabling the enter key to submit queries, fixing formatting in the footnotes, and improving guidance on how to ask follow-up questions. Second, there was a strong message about clarity of purpose. Several groups said that we needed to be clear about who the tool was actually going to be used by. And if forced to prioritize, it was recommended that we focus on judges first and get that right, and then expand carefully to other users. They also raised branding questions, such as whether or not this tool was an advisor, or whether or not it's more of just a legal information tool or a judicial compass, as one user called it. Third, the participants emphasized the scope of the tool. So the advice was to keep it narrow and do one thing really well, rather than try and solve all of the problems in one go, and then expand gradually through the tool and also through other jurisdictions. The aim really was to build a solid foundation around fair trial guarantees that we knew was going to work for across the world with the international standards. Then there was also strong support for domestic integration. So right now the Fair Trial Advisor is built on international case law and how countries can abide by their international obligations to uphold the right to a fair trial. Rather than keeping it international, several groups recommended piloting it in one jurisdiction and co-designing it with the local judges and lawyers and integrating it with the domestic criminal codes and procedural rules, and being clear about how international fair trial standards interact with national law. And then finally, there was a strong emphasis on accessibility and inclusion. Suggestions include jurisdiction filters, the ability to select relevant treaties, incorporating different languages, exporting and share functions, mobile optimization, and voice interaction for users with limited literacy. At the same time, participants cautioned against making the tool so accessible that it became over-relied on by judges. So I think the overall picture was this. Participants saw a real value in the tool, especially in saving time and delivering structured guidance, but they also made it clear that if this tool was going to be used to support fairness in courts, it must be focused, carefully scoped, and domestically grounded. There were a number of themes fairly focused on transparency, oversight, and responsible scope. So I will connect that with the data that I'm showing on the slides. So this should be question 8. If you look at the first graph, which asks what needs improvement in the tool, one area that stood out really clearly was citation and sourcing. This was by far the most frequently selected area for improvement during the hackathon. Participants repeatedly emphasized that the citations given to the user, whether that's a judge, a lawyer, or an individual wanting to know whether or not their fair trial guarantees have been violated, was that the citations must be clear, complete, and clickable. Users must be able to trace the answers back to the primary sources, not just the textbook that's the underlying data for the tool. There was also concerns about the transparency for how the tool works, and this was flagged as an area that needed improving. And in the discussions, participants asked, what model is being used? How is the data curated? How often is it going to be updated? And what kind of things are going to be excluded and why? And one really interesting example that we got from the hackathon was the tool actually being able to be used to overcome the fair trial guarantees. You could kind of use it to play devil's advocate and get around the fair trial standards. So that's something we're trying to improve. And there was also a strong view that if the tool is going to operate in the judicial environments, it cannot function as a black box. It must be clear the whole way through how it's being developed, the things that are being used to provide the answers, and where the data is coming from. And then we asked the participants what increases trust. Maybe that's, that was the question that was there before, I couldn't see. But the top ranked factors from the participants were clear citation of authoritative sources, evidence of accuracy, regular expert auditing and validation, transparency about how the AI generates responses, independent oversight mechanisms, and clear data privacy safeguards. So what people really prioritized over the hackathon was verifiability and independent scrutiny. Participants stressed that the tool must explicitly acknowledge its limitations, it must avoid overconfidence, it must not encourage over-reliance, especially among legally trained users who may assume it is more authoritative than it is. And there were also important discussions about judicial autonomy, cultural and jurisdictional sensitivity, and data protection. So what does this mean for our safeguards for the tool? Well, taken together, the feedback suggests that the ethical safeguards for the Fair Trial Advisor must include, first, a clearly defined narrow core function. Second, retrieval-based architecture grounded in curated authoritative legal material. Third, independent validation processes. Fourth, clear statements about limitations and appropriate use by judges, lawyers, or victims. Fifth, data privacy guarantees and clear retention policies. And sixth, ongoing updates and maintenance with visible last updated indicators so users are able to know how new the information is. In other words, the conversation shifted from can AI answer the question to under what conditions should the AI answer the question. And perhaps the most encouraging takeaway was that the participants did not reject the AI injustice principle, but in fact many saw that it had strong potential as long as it's clearly done right, and these kinds of things are being protected by the tools developers.
Great, thank you. This is very important for the tools and get all this feedback from the participants. So let's close by looking ahead. So Daisy, what are the next steps of the Fair Trial Advisor and what does this go from here?
Thank you, and that's the exciting part. This is really just the beginning of the Institute's work. The Institute only launched in October, so we're still really developing the tools in real time. I think the first step for us is going to be refining the tool. So we will continue to work closely with Microsoft's AI for Good lab to improve the tool technically, visually, and structurally. The version that I showed on screen was already a new tool that had been developed in the week since the hackathon, and we're going to keep trying to make sure that it's accessible and attractive for a user. So this will include addressing the usability feedback from the hackathon about navigation, clearer follow-up guidance, export functions and filters. And we're also hoping to have another hackathon to test the next iteration in the future. We also think that testing is going to be critical. So one priority is piloting the tool in domestic tool in a specific jurisdiction that we feel would really benefit from the use of the tool. We also want to pilot the Fair Trial Advisor in different judicial contexts, including regional courts or human rights bodies, one example being the African Court on Human and People's Rights. And we hope that this will ensure that the tool reflects different legal cultures and traditions. We are also exploring the idea of developing domestic AI tools, like I said, so not just focusing on the international standards, but also building specific domestic tools that can be used across different jurisdictions. The international version would focus on the global human rights standards and comparative jurisprudence, whereas the domestic versions would integrate local law and procedural guidance to ensure that fair trials are being protected not just under the international legal rules, but also under the domestic standards. Then on inclusivity, we are hoping to introduce different languages into the tool. This is one of our highest priorities, so that the tool can be made available in more local languages. Currently, it's only available in English, so this is a real working point for us. And finally, I think we'll just keep continuing to feedback to build upon the feedback that we've received. And like I said, the aim of the hackathon was never to provide a final project, but to try and ensure that the route that we are taking is the correct one, and that we are bringing in the people that are actually going to be using the tool to work out what's going to work well for them and how to ensure that we can make this product as useful as possible across different jurisdictions and across different users. So that, I think, brings me to my final point, and we're finishing early. If anybody would like to get in touch with us to talk about our work or the Fair Trial Advisor, I would really encourage you to do so. Like I said, we're interested in hearing everyone's perspectives, so please do reach out with any insights you might wish to provide, whether or not you're a data scientist, a lawyer, civil society, anybody. We'd love to hear from you. So yes, thank you very much.
Yeah, thank you, Daisy, for all these features and perspective that will definitely enhance the advisor. So with that, we will close the panel discussion and open the floor to questions from the audience. So I personally have many questions about this important and promising tool. But first, I would like to give the audience the opportunity to engage with Daisy first. So please, if you have any questions about this topic, you can get the microphone there.
Lawyer from just on the jurisdictions you're covering.
Yeah.
So you're focusing very much on international jurisdictions, but then are you breaking it down within sectors within those jurisdictions? So for example, what I'm alluding to here is, let's take the UK as an example. We have different rules, procedural rules for civil matters, intellectual matters, family. If you're looking at this internationally, family law is going to be critical, I think, for this. So are you breaking it down by sectors?
That's a really good question. And honestly, I'm not sure I have the answer, because the UK version is really in its early stages. We're just looking at how we're going to scope it out. Right now, the tool is focused on any proceedings that fit within the International Fair Trial Guarantees. So that includes things like tax proceedings. When it comes to the UK standard, I think we're going to try and make it as broad as possible, as long as we have access to the rules that we can feed into the tool to ensure that it's drawing from the right kind of material. But that's a really good question that I will be taking home with me to raise, and whilst we're exploring the concept of having, the domestically integrated fair trial advisor. Thank you.
If you have any other questions from the audience, yeah?
Hello, this is Amit. I represent Design Intelligence. You mentioned that citations are a challenge. So could you specifically explain what are the key challenges there that we as a technologist can address? Because in other areas, we have some great solutions to deal with the references and their cross-validation and appropriate citations. So what are specific challenges in the legal jurisdiction or the court cases and data that you need to refer to?
Thank you. One of the key things we were trying to resolve, and that's part of the reason why we're using the book as the primary data source, is the aspect of obviously the hallucinations and being able to trace back the source. If you're a judge using an advisor, it's really central that you have a clear route to track back to find the source, to make sure that you're relying on something that actually exists. So right now we're trying to make sure that not only is the tool taking you to the case that's cited in the book, but actually taking you to the actual case itself. Right now the tool will cite the case, but it will cite the page number that it's on in the book. And we're trying to make sure that you actually get to the original source rather than getting to what we say about, well, what Amal and Philippa said in the book. For the domestic version, the issue is then going to be making sure that this is the same thing. And like I said, we're still exploring that and trying to make sure that it's going to be as responsible as possible, and that there is that going to, avoid having that black box approach to the judicial AI tools. So I think that's the key concern, is really the traceability. Thank you very much.
Hi, my name's Aina and I'm from Agami. We work at the intersection of tech and justice in India. Something I'm curious about is if you were to ask a similar question on the right to fair trial to a generic LLM like ChatGPT, how would the answer sort of compare to a very specific chatbot like this one?
Thank you. That's a great question. So the book has actually only been licensed to for the Fair Trial Advisor. It's published by Oxford University Press, and Amal and Philippa were given the rights to use it within the advisor, but ChatGPT won't access it because it's behind the paywall of the Oxford University Press website. So that's the first thing, but also, again, then you've got the citation problem, which is what we're trying to fix with the Fair Trial Advisor, and making, whereas our tool will take you to the original source, anything you're getting online is probably going to take you to the commentary rather than the clear citable legal framework behind it. So, yes, but that's a great question. Thank you.
Hello, hi. I'm Mayank Sharma. I lead digital investigations at JS Held. I had a query. This is, by the way, it's a fascinating tool that you have here. Suppose for a moment the judge uses the Fair Trial Advisor to interpret a specific statute, and later that interpretation becomes grounds for an appeal due to maybe a potential hallucination or some sort of bias in the retrieval. Is the system logging the specific chain of thought? The reason I'm asking as a forensic investigator is that if I have to reconstruct why a judicial error occurred, would I be able to have access to these logs?
That's a really good question.
Or are the judges' interactions with AI privileged and therefore not open?
I think right now it disappears, and we're trying to make sure that one problem is obviously the confidentiality of the things that are coming in and making sure that the data protection is there. So right now the framework, I don't think, would be there. That's definitely something that we need to build on, and I think a lot of that will also come from the guidance that we're giving judges when using the tool, i.e., like we said, it shouldn't be something that's overly relied on. It's an advisor, not a decision maker. But I do think that's a key thing, and again, it'll be something that I'm taking home with me, and it's the benefit of having discussions like this to learn from these things and to receive these insights. So thank you. Yes. That's great.
Sorry, another. Does the tool, when you were referring back to the citations, so I'm assuming like either case law or a particular statute, but let's focus on a case law. Does it give the actual legal practitioner the underlying mens rea behind that citation and how it's been used? And the reason why I'm asking that is simply because using the example you gave of the client becomes ill and leaves court. Now, we all know that in every case, it'll be on the facts.
Yeah.
So the seriousness of the illness will determine the next step potentially. So does the citation retrieved from your tool give that degree of mens rea? It
gets the, I suppose, what you're calling the mens rea from the commentary in the book. So that is the answer that you get from the tool, but it's based on what the book says rather than what the underlying source says right now. And I think, again, that's one of the areas that we're trying to develop, is bringing in the actual tool underlying the book. Yes, but I do think that's, again, it's key. And yes. Yes, because otherwise, like I said, you don't want to become too over-reliant on what is essentially the commentary in the book. You want the underlying resource. So not only is that something that we're looking to do with the domestic tool, but also it's about improving the international tool to ensure that those kind of things are then included in the judicial response and the reasoning that comes from the reference to the tool. Sorry. Thank you.
Thank you for your questions. We still have time. If you have any questions, feel free to ask your questions. Otherwise, I have there is a question there. Yeah.
Hi, I'm Pragya, and my question is, what design choices separate the AI-created tools from legally dangerous chatbots? For example, there have been instances of AI hallucinations of lately.
Thank you. I think the difference is the data that goes in. As we've said, I think it's whereas if you've got a chatbot, you're not really having that protection against the hallucination aspect. Our tool, by using the RAG frame, which maybe Wasim can talk more about, it's drawing on the data set only. So it's supposed to be more authoritative in its legal guidance that it's giving, because it's based on this text, the underlying textbook and the sources within it, rather than drawing from multiple resources and having the potential to hallucinate some of the cases. But maybe you could...
Yeah, I can add more context for this question. Actually, the LLMs, or these generative models, starts to hallucinate usually when they don't have the question or the right answer, when they don't have the right answer for the questions. So what make these tools have less hallucination is we have all this data we are providing. So the tools can find exactly the right answers based on all these references, which are like more close to the questions that the lawyer might ask. And this makes the tools less hallucinating compared to other models, which are more general, but they might hallucinate because they don't have all these references in these specific topics.
Thank you. Is there any...
we can still take more questions if you have, otherwise I can... Oh, there is a question there, please.
Hi, this is Prasenjit here. So do you see this going beyond the scope of fair trial advisory? Like, will this expand into other data sets of legal jurisdictions, right? So, and how do you see that happening?
I mean, I think it would be great if it could, but the problem is having the rights to the underlying data set. And one of the things that we're really proud of for the Fair Trial Advisor is having it based on the textbooks. I suppose we could perhaps think about doing something related to freedom of speech, because we've got the freedom of speech book already integrated into the tool. But otherwise, I think we would struggle to expand it to different international rules and guarantees. But I would love to see those kinds of initiatives happening with other textbooks in the area. So.
Yeah, thank you, Daisy. I can ask you a couple of questions to explore different angles also.
Okay.
So based on what we have seen so far, what are the main challenges to scaling, technical, legal, and institutional, and how do these challenges differ between regions?
Thank you. That's a great question. I think the most obvious problem from probably a technical perspective is having the digital infrastructure in place and having judges that know how to use these kind of tools in their practice without becoming over-reliant on them. So that's, as we've seen with our AI Justice Atlas, which is one of the Institute's key initiatives, there's a real difference across jurisdictions on how courts are digitized, firstly, and how states are going about training their judiciary to deal with the challenges of AI. And I'm sure that these discussions are happening a lot this week at the summit. So I think that's one problem. Another problem is having the actual underlying resources, so the laws, the cases, the procedural guarantees digitized in the first place to have them fed into the tool. That's not guaranteed across every jurisdiction, and sometimes it's quite hard to attain, so that can be important for the comparison across the jurisdictions. And then I think maybe the scoping, deciding how and what kind of rules we want to include. I mean, that kind of picks up one of the questions from the audience, whether or not we want to include the fair trial rules in the family context, or whether or not it's going to be something broader. And I think that even that question can differ depending on the kind of rules that are available across jurisdictions. So yes, lots of challenges to think about in the months and years to come.
Great. Hopefully, we will see all these features integrated in the next versions of the advisor. So we still have time for questions. So we'll ask a second question. So given the statistics you shared earlier, backlogs, pre-trial detention, lack of training, what do you think the fair trial advisor could have the most immediate impact?
I think the most obvious response is the judicial case management and for the judges, kind of at the intersection of making sure that hopefully cases, criminal cases particularly, are decided more swiftly, and with the fair trial guarantees there to support them. So I think that's probably the key impact area, but I also think there's a real potential use by the parties and by the lawyers in the case to ensure that the fair trial is being conducted fairly, even if not from the judicial backlog perspective. So yes, but thank you.
Great, thank you. So maybe I will ask one last question,
okay.
Which I find very important. How do you prevent the tools from being misused? And for example, to tactically delay proceedings, for example?
Yes, I think that's a great question. And like I said at the hackathon, it wasn't funny, but there were some examples of some of the participants in the room trying to get the tool to play devil's advocate and give it advice on how to overcome the fair trial guarantees and make sure that they weren't going to be held accountable or something worrying. But I think that's a real problem, and it's, again, something we're exploring the solution to with the AI for Good lab. It might be that we decide to limit the scope of questions that the tool can answer, and maybe that it will be that the tool decides to give it a straight no to that kind of question, but we don't really have the solution yet, and that's one of the great things about the hackathon is that we were able to learn about that problem in the room with the participants, which we maybe may not have learned ourselves. So, yes.
Yeah, to add more context for these questions, we can still also fine-tune these LLMs with alignments to make them don't answer all these toxic questions, for example, or limit the scope of answering only questions related to these topics. So with that, I would like to close the session if there is no more questions from the audience, since we have more time. But otherwise,
hello.
Yeah, there is question
One
here.
at the back.
So I just want to ask, it works offline without internet?
Sorry, could you repeat the question?
This tool works offline without internet?
Not right now, I think. It currently relies on the internet access, but that's a really good question as well, and again, something we will need to consider. Muslim, I don't know if you have any insights on whether or not that's even possible.
Yeah, this is the next step we are considering. So we will have two options. The first one is online access to this tool. Like the LLMs will run on remote servers, and we need connection actually to access to the LLMs. The other options we can also offer is to run everything locally, but this will need also some compute requirements to deploy the model, the inference also to perform the inference in real time. So first we are providing this through internet access, which is secure access to internet. But the second option can be also considered for local deployments of the system, for more secure deployments. But of course, this will need some requirements from the providers to be able to run the LLMs locally for real-time inference and optimization.
And another last question is, how much lawyer is now syncing with this tool in the commercial perspective? How much they want to buy kind of this tool? How much spending they have for this?
How much they're
Spending. Is there any? How if they want to deploy the tool, they must be the budget, no, for this. Is a cost, right? So as per your survey, what is your?
The tool is going to be, we're hoping, open access. So there shouldn't be any sort of requirements on any financial income or for us as the institute. And it's being developed by us within the institute with Microsoft's AI for Good lab. So yes, I think.
So is it free for the lawyers?
It will be once it's available. It's currently still in the prototyping phase, but I'm pretty sure that's the...
Yeah, usually how we operate at AI for Good Lab, at least, like we provide everything open source. Like all the materials will be open source. If any institution around the world want to use it, they can take all what we are providing, they can deploy it, and we might also in sometimes provide some technical expertise if you have any issue in deployments, etc. But it's not a commercial product that you can buy, deploy. It's something that we provide for free, open source for everyone, and we can provide more technical expertise if you have any issues in deploying this system. But it's not a product, like it's just a prototype that we are providing for open.
Okay, I understood, but I just want to understand how lawyers are now syncing with this, how many percentage like lawyers are comfortable with this tool? How, in percentage, how many lawyers are comfortable with this tool, like they like to use it and they want this transformation in their firm, in individual level, like small lawyers, big law firms, whatever?
We haven't got the data on it, but we'd like to think that everybody wants it.
Great, thank you. That is what I want. Yes, nice, thank you.
Yes, I mean from the hackathon, like I said, the response was positive, in that everyone was saying that it was going to help support the fair trials, but that was from a mixed audience that didn't exclusively include lawyers and judges. So, but like I said, I hope everybody wants to use the fair trial advisor. Yeah. Yeah.
Sorry. We're very nervous from an insurance perspective about reliance on such tools as opposed to our own training and our own backgrounds.
Yeah.
But there is still a lot of enthusiasm because anything that helps to do our tasks and do it in a way in which is within the rules as well, from our perspective,
yeah,
is generally welcome. But most law firms are embracing it, but there needs to be... most law firms are also having to employ incentives for practitioners to use it.
Yeah. Well, thank you for the positive response. But yes, and I hope the same is true for courts, where there's the infrastructure and training in place for it to be done responsibly.
So I have a question. My name is Robin. I'm a lawyer. I'm a legal compliance lawyer. So how this kind of tool help to address the pendency in court, especially in India where we have large set of pendency? Can these kind of tools assist the judges to sort out that pendency? Are we targeting that?
Could you just repeat the question a little? Sorry, I was just struggling to hear with the background.
In India, we do have a lot of pendency of court cases, and that is a bit struggling because we have less number of judges and the cases are huge. So I feel that AI can really help to address that part, because like you mentioned in one of your slides that this tool can help to reduce the time to research.
Yeah.
So can it really address that part?
Yes, we hope so. Particularly in the, like I said, the kinds of cases that fall within, when we're using the international tool, the right to a fair trial. Instead of looking through 1,000 pages which summarize 28,000 decisions on the right to a fair trial, having something that you can just type into the computer and get a response within a minute, probably maximum, we hope will help with the backlog problem, particularly in the kinds of criminal cases that would really benefit from the use of the tool. So the answer, I hope, is yes.
And how are we integrating legal education or training part with these kind of developments, especially AI and legal area? How are we integrating the legal education?
That's a great question. I don't know if that's something we can resolve as an institute. I think it's something that is a much bigger problem around the world. We would like eventually to include guidelines on how judges can use the tool responsibly, as I've said. But in terms of the broader training that's required to understand the tool and how much reliance should be placed on it, That's ultimately something that we are advocating for as an institute, and we're collaborating with UNESCO on their MOOC about judicial AI, particularly on fair trial guarantees. So it's these kinds of initiatives that I think are really crucial, and if we can find a way to integrate our projects within them, then I think that's great. So yes.
Thank you. Thank you.
Thank you.
Okay, if we don't have more questions from the audience, there is one question that, yeah, please.
Thank you. We have a lot of content, and you process that content using AI tools, the LLM models, on the data, and data comes from varied sources, and that's what the referencing challenges we discussed earlier. Now, we have three things: data, model, and presentation. So if you look at the other industry, for example, in healthcare, for doctors, when we provide solutions, we call them giving aid, not necessarily decision support. It's not necessarily the final outcome that they should implement. Whereas in manufacturing setting, we do take that as a final outcome that can be implemented. So presentation becomes a real key important driver for implementing that decision. So now when it comes to court cases, you have presentation framework. I think that might be need to be included in the tool. Why I'm saying that? Because if you look at case paperwork, or if you look at affidavits that are on the bond paper or stamp paper, and that is design. And a lot of that data is to do with not only the text, but also the graphic processing, the image processing aspect, recognition of that, and then recreation of that, so that reports and the lot of paperwork that goes into doing into court proceedings can be either as an evidence, and then post-processing of all of that needs to be included. So I think the tool needs to have a presentation framework as well, not just the dashboard of monitoring statistical aspects and analytical aspects of data, but also reporting mechanisms. So what are your thoughts on that? Thank you.
Thank you. Do you have any?
Yes, I can answer this question.
Okay.
I think it's very interesting question, and I think I think now with LLM we can integrate the call to many other external tools to process the data. And I really agree, like, with what these tools is providing is not the final decision. It's just providing some references, guidance to speed up and take the right decision to the lawyer and the judges. And in terms of analysis, of course, this can be features that can be added. It can be directly integrated into the tool, or calling some more specialized tools for data processing, for example. And in terms of input, for now we are considering only text, but in the future, one of the features we can add also is to consider speech, from converting the speech to text, and also consider multimodality, that we can provide an image, a video that we can process instead on only text. This can be like real new features, very helpful, useful, that we can add at the input and also at the output, processing, analyzing the data, providing the best feedback to the lawyers, the judges, that they can take right decisions and reduce all the delay they might have without using AI tools.
Thank you.
Welcome. Okay, I think if we don't have more questions, there is one here. Yeah, please. We still have time.
Yeah.
Hello. Yeah. So first thing, just I want to ask, this is a tool, right? So I just want to understand, on the back end, are you using some generic LLM, or you have your own thing on the back end, how it works?
Yes. Of course, we are not developing proprietary tools for this case. We are using existing LLMs. I don't know exactly which LLM we are using because we have access to, in the Microsoft Foundry, all existing LLMs. But the idea here is the approach is using a RAG, retrieval augmented system, then training this new LLM. So the idea is we provide new data. With the RAG, we can access to the right data according to the input of the user. But in the backend, the idea is to use the most efficient existing LLMs with additional context that comes from the data we are providing to the tools. So the idea here is not to build a new LLM, because building LLM, it's a very high cost and it needs huge data. And it doesn't make sense to train LLM only on this data, because it's relatively very small to existing data used to train LLM. But the idea is to leverage the best existing LLM that we can access to and use them with a RAG system.
Okay, nice. Thank you. Thank you very much. Yeah. So I just one more question. Is it fine?
Yeah, we have still 2 minutes.
Yeah. Thank you. So last question is, if you are existing LLM, so is there anything you can use any model. So if any developer want to change the model, is it possible?
Yeah, as I said before, if for now we are not offering this feature, like the LLM which is used is fixed, but we have to explore first to offer this possibility to select the LLM. We have to explore how the responses differ with different LLM, which one is the best for this case. I think for that we need more testings with real users to get the feedback. But what we can offer, at least when we can use the system offline, we can offer the possibility that the user can use any open weights LLM locally, like which is independent from what we are providing, but we just give them the API that they can use any open weights LLM existing on Hugging Face, for example, but they can run locally with the right license, etc. But we are not managing this part. This is up to the user to deploy whatever they want on LLM. But the idea is to make it open to use any existing LLM.
In that scenario, you are providing the basic structure and the person using the API can customize it as per his needs and all, I understood. But in that case, you are, what about the tokenization and all this stuff? So like, that is handled by you or what?
Yeah, all tokenizations are part of LLM, so we don't operate or touch this, because when you have tokenizer, it is already optimized for the LLM. So changing the tokenizer will not help, like getting better performance, etc. So I think the idea is just to be able to use different LLMs at different scales. For example, 4 billion, 10 billion, 15 billion, according to the performance we want, and also to the compute capacity we have, if we want to integrate it internally from the user perspective.
Okay, so what I understood, so if I want to use the tool, I have to purchase some key of OpenAI or something and integrate in your tool like that. So I can build to the OpenAI for the tokens.
For us, we are not specifically relying on OpenAI. We are using all LLMs that are deployed on Azure Foundry, which is a Microsoft tool. But the idea, yes, if you have like the key to access to this service, you can use any LLM offered by Azure Foundry, for example.
Okay, great. Thank you. Thank you very much.
Thank you. Yeah, thank you very much.
Thank you.
Thank you.
Good morning, all. Thank you for joining session. Your exit is behind you only. And right-hand side, exit behind. Back.